Yes, Mr. Jafferty.
Good morning. I just wanted to check a few matters in relation to bundles. I think there was an application that was sent yesterday, and also the recording. And I think me and my learned friend are uncertain as to what the Court of Appeal would like to do with the recording.
Yes, well, shall we deal with the recording? Has the case been called on? It has.
Yes.
Yes. Sorry, I just didn't notice. I'll wake up in a minute. It's the view of all. We've all listened to the tape. It's the view of all three of us. There's no point listening to it in court. It'll create complications. It's important that we have listened to it because it's always helpful to confirm the impression you get on paper by hearing the audio. But there's really no need for us to listen to it.
I'm grateful. It was just that I think the order of Lady Justice Lang was a little bit ambiguous in terms of whether she was expecting it to be played or not. But
I see. Yes. Well, whatever she intended, that's what we're going to do.
I'm grateful, my lord. There is also, and can I apologise, my lord and my lady, for the late skeleton. You will have seen the explanation for that. Things have been moving around.
Thank you for your apology, but no harm done.
I'm grateful, my lord. And finally, there is an application that was submitted yesterday. I'm not sure whether it's opposed. We have, I think with the application, submitted the documents.
Yes.
Yeah.
Well, we can find out whether it's opposed, but the view we were going to take at this stage was simply to look at them de bene esse. It may well be, is a very provisional view, that they don't actually advance matters very far, but I think it's useful that we have seen them. Ms. Anson, if they're not opposed, we'll admit them, but otherwise we'll look at them de bene esse.
Well, my lord, I'm very content with the approach that's been indicated. In terms of, so we don't have to go to submissions, in terms of my position on admission, I would say without prejudice to my submissions that they're not at all relevant, then I've got no objection I'm neutral really on admission. So
that's very helpful.
Leave it rest on the wisdom.
Well, I think the sensible thing is we'll take a final decision on admissibility as part of our decision when it's become clear how relevant they may be. But they're clearly documents which, once the issue of the visits had been raised, any court would feel uncomfortable not having the best evidence possible as to what had been said.
Absolutely, my lord. No, so I've got no sort of objection. It's just how it fits into the appeal at this stage. That's more
thank you very much.
And my lord, the final issue is we're a bit uncertain as to what the court is expecting in terms of timing, because
we're not expecting it to last a day and a half. That's
right. I just because I gathered from somewhere, and it was confirmed this morning that it's listed for 1.5 days. But that I'm grateful.
Frankly, if counsel are as economical as I'm sure you'll be, I wouldn't be surprised if it was a good deal less than 1 day. But you'll no doubt say you want to wait and see how many questions are asked.
Yes.
But really, the issues, with the benefit of both sides, helpful skeletons, and our having, I hope, accurately mastered what happened in this case, the issues are really quite narrow.
I'm grateful for that indication, my lord. So I will start by just taking my lords and my lady through the background as quickly as possible. There is a lot going on. Usually we have a determination that's being appealed. Here we have a determination that's dependent on an FTT determination, which is the actual issue, and we also have a transcript. I wanted to take my lords and my lady just through the background so that the
Please,
context...
well, I think any appellate court is a little bit nervous when they're told to be taken through the background, because the background is certainly what we ought to be familiar with from having pre-read.
Yes.
But we'll wait and see what comes under that heading, but we may hurry you up a bit.
Yes.
Perhaps I can just comment on one point you made. I think it will, of course, be necessary to examine the reasoning of the upper tribunal if we said we got it wrong, but you're right, that's not the focus of the inquiry. The focus of the inquiry is what happened in the FTT.
Yes.
And if there was unfairness or bias, whichever label we wish to use there, and we're satisfied of that, then one way or another the upper tribunal got it wrong by finding there wasn't.
Yes, yes. So, my lord, if I could take you first of all to the interview record, which is at page 249 of the bundle. That's essentially where it all starts, because prior to a decision, there's an application, and prior to the decision being made on the application, there is this interview record.
Yes, so which page did you say?
247 of the bundle.
Yes.
And I won't take you through the interview record at all, just to observe, I have in the skeleton set out the length of each interview and the number of questions.
Yes.
There is also a schedule that sort of summarises what happened during the interview in terms of the way that questions went. And my submission would be that it's not an interview that was clear-cut one way or the other. There were certainly answers that the two parties got right and clearly demonstrated significant knowledge about each other. There are other areas where they didn't have knowledge, and it could be said that that knowledge would be expected of parties that were living together. But neither side, if I can put it that way, could say that there's a smoking gun from the interview itself. And my lords and my lady will see that at the start of the interview record, you have the interviewer recommendation, and that recommendation is marriage of convenience, and the interviewer clearly sets out the basis upon which that recommendation is made, and that is then followed up with the refusal letter. And we've just noticed this morning, my lords and my ladies, that the refusal letter is the one document that is not in the core bundle.
No, well, I noticed that, but it appears to be quoted fully
Yes.
in the FTT's
Yes.
decision.
And I don't think there's any issue between the parties that the refusal letter is focused entirely on 5 areas which the decision maker says demonstrate a lack of knowledge between the parties as to each other's circumstances.
I think for good order's sake, if you, although I think it's all there in the
Yes.
FTT, if either party, I'm assuming certainly the Home Office will have, you should both have a copy of it.
Yes, we do, my lord.
Well, perhaps as you're on your feet, perhaps you could ask your junior just
Yes.
to
Email
email it to us so that we have it.
Certainly.
May be more convenient when
Yes.
writing the judgment to have the actual document.
I'm grateful, my lord. We will do that. And so by the time of the appeal before the FTT, so by the time the appeal is instigated, the Home Office has carried out an assessment of the application and the marriage, which includes a lengthy interview and consideration of documentation that was submitted with the application. And the Home Office has said these are the reasons why we do not accept that this marriage is genuine, and the Home Office itself is asserting that the marriage is one of convenience. The appeal is then filed, and the procedure before the First Tier Tribunal is that prior to the hearing, the appellant submits an appeal bundle and an appeal skeleton argument. And that appeal skeleton argument is at page 103 of the bundle.
Sorry, 100 and...
103, my name.
Thank you.
A 103 our bundle.
Yes, the core
I think it's I think you mean 101.
Apologies.
Oh,
because
it
I'm
may be
drawing-
it may be one of these cases where the paper bundle is paginated differently from the.
No, it's paginated 101. I'm sorry, my bookmark has it as the PDF number. My lord is right, it's 101. And what my lords and my lady will see from the skeleton argument is that there, the appellant very clearly sets out his strategy. And so at page 102, the second page of the skeleton, you have the subheading Issues. And in the second sentence of paragraph 2, the appellant says that in making the assertion, the respondent raises the following points and identifies them. And then you have the legal submissions from paragraph 8 onwards. And that foreshadows the submissions made before the First Tier Tribunal judge about the burden of proof, the evidential burden. At paragraph 9, in the last sentence, the appellant relies on the respondent's reasons being confined to 5 issues. At paragraph 10, the submission is that that low evidential threshold has not been met by these 5 issues. The skeleton then goes into each issue and addresses why it is said by the appellant that those are not serious issues. Paragraph 16 concludes that the respondent has adduced nothing of significance that can give rise to a prima facie accusation. And then at 17 goes on to say, if the court disagrees that the evidential threshold is not met, the court is invited to assess the appellant's response contained in the witness statement. The appellant has provided logical and plausible response to all of the issues raised by the respondent, and then goes on in the following paragraphs to...
It's rather odd, when it says appellant's oral evidence, that's a slip, is it, or is it a prediction?
Could be either, my lord.
If it was a prediction,
Yeah.
it was it didn't come to pass because he was never cross-examined on any of these points.
My lord is right. But he did give oral evidence, so he presented himself for cross-examination. One of the
Yes.
curious things about the appeal is that in terms of clarification, the First Tier Tribunal judge did not clarify any of the issues that were raised in the refusal when asking
No.
questions. And the appellant's submission is that that is because by that point in the hearing, he had become so, in the words of Upper Tribunal Judge Bruce, infuriated by the strategy that he was entirely focused on that strategy. And that is why his questions were focused on addressing that strategy. And we would say that he had strayed into the forbidden area of now seeking to undermine the strategy by asking his own questions. But my lords and my lady will see that the skeleton clearly envisages two submissions. One, that the initial evidential threshold is not met, and so the respondent's case fails. And secondly, if it is met, the overall burden is not met because the appellant has provided an explanation, and overall the burden simply cannot be discharged on the basis of those 5 areas of discrepancy that the respondent had identified in the refusal. That is then followed by a review by the respondent, which is at page 97 of the bundle. The first paragraph confirms that the respondent continues to rely on the reasons for refusal.
Can you just help me on this?
Yeah.
I haven't quite seen this procedure followed. I mean, nothing necessarily wrong with it, but this is not therefore an administrative review under the rules.
No.
It's basically the Secretary of State saying, well, now I've seen your case, I'll have another look at it.
Yes.
And if I don't accept it, I'll say why.
Yes.
So it's effectively a skeleton argument, but based on a reconsideration rather than a...
My lord, yes. And I think this started in COVID. During the COVID lockdown, the First Tier Tribunal introduced a system whereby there would be a pure skeleton argument, a review, and then the issues are identified for the tribunal prior to the hearing.
Yes, thank you. I hadn't come across it before, but that's helpful. But effectively, this gives the Secretary of State's answer.
Yes, my lord. And my lord will see that at paragraph 2, it refers to the schedule of issues and counter schedule below are clear on what matters are now accepted.
Hang on 1 second. Yeah.
And the counter schedule, which begins at paragraph 6, is the respondent's schedule of issues. And my lords and my lady will see that the grounds of refusal are maintained. The responses that the appellant has given to the discrepancies are addressed. It is also, the further evidence provided is also considered.
This is a convenient guide, is it? This paragraph to what had come in since the original decision.
It is a convenient guide to what had come in. It also confirms that by the time of the tribunal hearing, the respondent had accepted that the appellant and his wife live together, they do cohabit, but continued to assert that the relationship was not genuine. And that is relevant because, again, in the determination, the First Tier Tribunal makes a mistake. Well, I don't think it makes a mistake, but it inexplicably goes behind that very clear concession. So the last sentence of the paragraph that begins on the bottom of page 98 and continues to the top of page 99 confirms that it is accepted on the part of the respondent that the appellant and the appellant sponsor live together. But then the next paragraph goes on to say that that doesn't mean that the respondent accepts that the relationship is genuine. Joint residence is not indicative of a relationship and merely demonstrates cohabitation. And then at paragraph 7, the final paragraph of the review, it maintains the reasons set out in the reasons for refusal letter. Nothing extra is added to what is said in the refusal letter. That then leads us to the hearing, and the transcript is at page 190. And I'll just very quickly take yours and maybe through the transcript. I'm mindful that you've listened to the recording.
No, absolutely, this is important, so do take us to whatever you need to.
So the start of the hearing is at page 191. And Judge Mills, just over a third of the page down, when he begins, this is a case where marriage of convenience is asserted. Clearly at that stage must have known what the appellant's strategy was going to be, because it's set out very clearly in his skeleton and addressed in the review. So he
well, it's not. He must have. He says in the next sentence that he actually identifies the strategy.
Yes, and so right at the start, clearly the judge is concerned about the fact that he's not going to hear evidence from the wife. And so after the initial exchange, he goes on.
Without prejudice to the points that I know you're going to go on to make.
Yes.
Is it part of your submissions that he shouldn't have been surprised by this strategy?
Yes, certainly. He shouldn't have been. Well, is my lord saying he shouldn't have been surprised in this case, or just generally as an experienced judge?
Oh, I see. Well, I'm not sure I was thinking about it so sophisticatedly. I was really just putting to you that it might be thought surprising. The judge did think it was surprising that you would fight your case on the strategy, which, as you say, was clearly a considered strategy, when you could reinforce it by producing the evidence primarily of the wife, but perhaps also other family members, to say, yes, they're a couple, and give various particulars.
My lord, absolutely right, and it's always a difficult balancing exercise. My submission would be that Mr. Hussein's strategy was not a wild and unique strategy that the judge would have faced or heard of for the first time when he read that skeleton. I think it's a strategy that representatives do adopt, and there's good reason for it, because the burden of proof in this particular circumstance rests on the respondent, and the respondent has already had a chance to test the relationship. And that's why the length of the interview and the number of questions is important, because there's been a full opportunity to test it in circumstances which are, one would say, perhaps not as advantageous as a court hearing, because you're in the respondent's den when that's happening. There's no judge arbitrating, you're just being asked questions. There's no preparation in the sense that you'd have by the time you get to an appeal hearing. There's just questions, lengthy ones, and then the respondent has made a decision based on those answers that this is why I think the relationship is one of convenience. Now, Of course, if both parties give evidence, that's a further, one could say, opportunity for some fishing to see if there are other discrepancies that arise. If those explanations for the discrepancies that have been identified are actually decent explanations, well, we can find something else. And it's always difficult, my lords and my lady will know that when one is giving evidence, it's rare that two parties will give evidence that is entirely consistent. One would expect inconsistency. I always remark to whoever is listening to me when these cases come up that if I was asked questions and my wife was asked questions about our last month, we would get things wrong because people perceive things differently, people remember things differently.
But you might expect a judge who knows the way of the world to know that that's the case.
That's right. You might expect that, but of course here you've got an appellant that comes to court with some baggage. That baggage clearly was something that had an impact on the judge's mind. He mentions it repeatedly. It's not something that the respondent relies on in the refusal. There's absolutely no reliance on the appellant being a person that simply cannot be trusted. The respondent, I would submit, drafted the refusal in an entirely proper way, which was that the background gave rise to suspicion, but that suspicion ought not to find its way into assessing whether this relationship is genuine. One assesses this relationship on the evidence that we have in relation to it.
Well, I don't want to anticipate this if this is something you're coming to later, and I'm not ultimately sure it goes to the heart of the issues in this particular case. But in case we might want to say something about whether this was a sensible strategy or not.
Yes.
Surely in the real world, a judge not only will, but ought to take into account what you've described as the baggage in deciding what the inherent probabilities are. Is this the kind of person who might be expected to, for whom it is plausible, perhaps is a better way of putting it, that they would enter into a bogus marriage in order to get round the immigration system? And I think it's unrealistic to suppose that a judge, well, a decision maker, shouldn't take that into account. It's not decisive.
Yes.
But in deciding the inherent probabilities, you then take it with the specific evidence of discrepancies or whatever it might be in the particular case and decide the matter in the round. That's a legitimate approach, isn't it?
My lord, I think the way I would answer that is that the approach in these cases, which are EU law cases, where the marriage itself is sufficient to give rise to the right, subject to a finding that the marriage is not genuine, and therefore it's an abuse of rights. So it's slightly different to the context one would have in an immigration rules case, where the appellant always bears the burden of establishing every single item that he has to establish in order to benefit from the relevant rule that he wants to benefit from. Here, the case law has developed in a way that I would submit reflects the approach that the respondent took to this. And I would submit that that is the appropriate approach, which is that the background is what the respondent would look at to see whether this is a case where there should be any suspicion that then gives rise to the investigation, because one ought not to have a position, and the position under EU law is that one doesn't just have a system whereby any person that says I'm married to an EU national is then subject to an investigation. That isn't the way it works, and it's supposed to work, and that isn't the way that the respondent has dealt with these cases. So the background gives rise to the suspicion, and my lords and my lady will see that that is the way that the presenting officer before the First Tier Tribunal put her case and put the respondent's case. That gives the context to the suspicion. You then have the investigation of the marriage, and the investigation of the marriage ought to be focused on the evidence that the decision maker has as to the relationship. Now that could be whether they're living together. There are sometimes visits by immigration officers to the premises where the parties are staying to check whether they are living together, check what possessions are there, all sorts of things that can be done and sometimes are done. They're not always done. In this case, we just have an interview, but we have an extensive interview. But I think for the purposes of this appeal, what I would say is that even if the judge had been entitled to say that in assessing the burden of proof overall and whether it's been discharged, I'm entitled to take into account that I don't trust the appellant because of his background. At the very least, that ought to have been made clear, because it certainly wasn't the way that the case was put by the respondent. And I think that is also at the heart of this appeal. How does a first-tier tribunal judge deal with an appeal in an adversarial system where the respondent has said, this is why I say the appeal should not succeed, particularly in a case where the respondent bears the burden of proof, and the appellant then prepares his case on the footing that these are the issues that I have to address. And even if it was legitimate for the judge to say, I'm going to take into account this background, the appellant ought to be given proper notice of the fact that that is going to filter in to the assessment of the actual marriage itself, rather than the entry to the allegation that this is a marriage that is one of convenience, if that makes sense, the distinction between the two, because that is the way that the respondent put his case at the FTT and in the refusal.
Well, turning that into what ought to happen, you say, if we were going to give any guidance for future, on this fallback part of your case, you would say, well, if, which you don't accept, the background is potentially relevant, the decision letter should say, here are all these specific discrepancies, and in deciding whether these are just innocent discrepancies or indicative that this isn't a genuine marriage, we take into account your appalling immigration history and the various deceptions you've practiced already in that connection. And if that is then on the table, the person whose decision is being challenged knows what case they're coming to meet. That's really how you put it.
Yes, my lord. And of course, on the particular facts of this case, what might have been relevant in terms of the way that the respondent put his case, the appellant was the subject of 2 previous determinations of the First Tier Tribunal in relation to a previous relationship.
Yes.
The judge only had access to one, and we only have access to one, which is in the bundle. There was a previous determination which the previous judge, Judge Shiner, refers to.
This is by Judge
Omotosho. That's right,
yes.
my lord. And both of those determinations proceed on the basis that the previous relationship was genuine. So there is that background as well. Somebody with an appalling immigration history, but an accepted relationship that was genuine and that would have given him an immigration advantage potentially. And so it might be that is the reason why the respondent did not press upon the immigration history being a credibility issue. We don't know, because it simply isn't addressed in the refusal, so we don't know why it wasn't addressed, but clearly it wasn't. And of course that is relevant to assessing his credibility now. This is not somebody that is turning up with a second marriage that is a sham. The first marriage is never alleged to have been a sham. And I'll take my lords and my lady to the determination of Judge Shiner. What it shows is that Judge Omotosho heard evidence from both the appellant and the previous partner and made a finding in relation to the relationship based on hearing that evidence. And that was never challenged subsequently. And there's a lot of other evidence that sort of was relevant to the position taken by the respondent in the appeal proceedings before Judge Shiner. But I'll come on to that.
Yes, I don't want to take you too much out of your course. That's been helpful. But just one thing that's been off from this, I meant to check and didn't. As you say, this is not a conventional immigration appeal. What's the actual, jurisdictionally, how does the question of a refusal of a residence permit get to be appealed to the FTT?
I think it would have been, my lord, in relation to this appeal via the 2016 regulations, which then apply the 2002 Act in relation to appeals against decisions refusing a residence card. So
Yes, is that if that's in the skeleton somewhere? I didn't.
it's not in the skeleton, my lord. I can certainly provide that background afterwards.
I think again formally it would be.
Yes.
And is the position though that on such an appeal, as in other immigration contexts where there is an appeal at all, the tribunal is a primary fact finder. It's not just a reviewer.
That's right.
Yes.
That's right.
Yes. All that sounds right, but
Yes.
it'd be useful to have
Yes.
chapter and verse on that. And just for my general education, at the time that this arose, the Withdrawal Act still hadn't come into force, so we were dealing with the regulations which were themselves based on EU law. Do those regulations remain in force? Are they retained EU law?
Only for the purposes of appeals, as I understand it, that were pending. So historic appeals against, not historic appeals, but appeals against historic decisions or decisions that are sort of taking some time to be made. Otherwise, they've been repealed. But they still apply in relation to those appeals where they are relevant.
Well, I think I won't invite you to give us chapter and verse on that.
Yes, but I think the general principle, I think, will still be relevant to appeals even under the EUSS, because the assessment of relationships will still follow the EU law model, so that anybody.
So if in an eventual judgment we said something like, and Ms. Anderson may want to give us chapter and verse on this, it'll affect her more than it affects you, that the particular regulatory scheme under which this issue arose is no longer in force, but it appears that similar issues may continue to arise under the under effectively EUSS or derivative rights under the EUSS.
Yes.
That would be a fair summary as far as you understand it.
I think so, my lord.
I'm really just raising this so that Ms. Anderson knows what to say when she gets on her feet.
Yes.
Yep. Thank you.
So
right,
Lord,
sorry, that's we've taken you out of your course, but I found that helpful.
Not at all, my lord. 191, we're just looking at the introductory remarks, and Judge Mills says, when Mr. Hussain answers she's not giving evidence, right, okay, well, I do not need to tell you that in a case where marriage of convenience is asserted, it is normal for both parties to that marriage to give evidence and be subject to cross-examination in order to prove the genuineness of their relationship. And I accept that Judge Mills elsewhere does properly state that the burden is on the respondent in relation to this. I accept that. But that remark, in the context of what comes later and throughout the course of the hearing, and the fact that the strategy was clearly known to everybody in advance of the hearing, does give cause for concern, because the approach and the mindset seems to be that it's normal for the parties to be subject to cross-examination again, and that cross-examination is their opportunity to prove the relationship, which is actually the converse of the position that is correct under law. And that mindset, whether that was at the forefront of his mind or at the back of his mind, might well be the genesis of his irritation and frustration and infuriation, I think is the word that Judge Bruce uses, as the hearing developed. But that is wrong, and that is something that is relevant to the appearance of everything, because there is that distinction between appearance of bias and whether the hearing was substantially fair. And as a matter of appearance, a well-informed observer would, in my submission, take account of that. And he repeats that at the bottom of page 191. Why would you not bring the best evidence for your client, which is oral evidence from both he and his wife, confirming the genuineness of their relationship, subject to testing under cross-examination? And that, in my submission, is simply not the proper approach to the reality in this case, which is that the respondent bore the burden. The appellant could just remain silent. The respondent still had to prove that the relationship was one that was not genuine. And it's in that same paragraph from the hearing where Judge Mills then goes on to say that I need to make it clear to you that I may make an adverse inference. And the inference issue is important in my submission because it suggests a very firm mindset that there should be evidence from the wife that should be subjected to testing under cross-examination, but it also demonstrates an uneven-handed approach to the parties, because when it came to lack of evidence from the respondent, the judge expressed no frustration, no remark as to why it was not there. In fact, one could say that he was sympathetic to the presenting officer because the presenting officer did not know about a visit which, of course, the presenting officer herself is not culpable, it's the respondent as whole. The respondent should have known, or must have known, had constructive knowledge of it and should have put before the tribunal. And that failure to put that information before the tribunal has led to a clear error at the FTT, because by the time of the upper tribunal and by the time of today's hearing, we know that there were in fact 2 visits by immigration officers. So the appellant was not telling an untruth in relation to the 2019 visit. My Lord, in relation to these opening remarks, I would just say that Mr. Hussain, and my Lords and my Lady will have heard the recording as well, Mr. Hussain does remain calm. I'm not saying admirably calm, because Judge Mills was also calm at this point, but he does remain calm and he does make his points very clearly to the judge, so that he's explaining to the judge exactly why he's doing the things that he's doing. And there is, of course, this was taken at the upper tribunal. The upper tribunal was not very impressed with the point, but it is relevant to appearances that the judge does, on a couple of occasions, say to the presenting officer, I'm assuming this is what you're going to ask me to do. And then the presenting officer says, yes, Judge, that is what I'm going to ask you to do. And that is not to say, Judge, that it's impermissible for a judge to ever say that, but one has to read everything in the context. And the question in terms of appearance of bias is, how is that going to appear in the overall context of the way in which this hearing is unfolding? If we go to
Can I just be quite clear? Yeah. Your primary submission is that it was wrong for the judge to say that, or to give a warning that he might draw an adverse inference from the failure to call the wife, because I mean, it's very like a criminal context. And, 20 years ago, you'd be telling, let's defer to my lord about this, or 30 years ago, you would have been telling the jury they mustn't draw an adverse inference, and you're saying that's still the position. Now you'll be telling them in cautious terms they could draw an adverse inference from the failure to produce evidence that they might have been expected to adduce.
Yes, my lord.
Is that roughly right?
My lord, if
it just seems a little bit
yeah.
I mean, the judge has been very frank, but is he not really being? Is his position wrong?
I wouldn't say, my lord, that the judge's position at the outset is wrong in relation to telling the representative, this is what I think of the case, this is what I would expect. That is often very helpful, because the representative knows exactly what is in the judge's mind and knows what case he has to meet to persuade the judge. The difficulty is that one cannot simply say that the judge gave the representative a warning or gave him notice of his thinking on the case, because one has to look at everything that he said and the context within which he said it, which includes what comes next.
Well, I'm sorry to be, you're being very, in a way, you're being very clear, but I just think, just want to absolutely pin you down on this.
Yeah.
You say rightly that in principle, for a judge to raise a concern is always helpful. All
Yes.
advocates like that, because they know what they've got to deal with, and
Yes.
sometimes it's possibly necessary if it's something you may not be expecting. No problem with that. But are you saying that although good for the judge for saying that he was minded to draw an adverse inference, actually he shouldn't have been minded to draw an adverse inference, and that he should have accepted Mr. Hussein's submission that no adverse inference could be drawn.
I think my lord makes a good point that at that point of the hearing, to tell Mr. Hussein without actually hearing the evidence that I'm minded to draw an adverse inference is very serious, and he repeats that. He tells that to Mr. Hussein, I think, on a couple of occasions, says that that's what the presenting officer is going to ask me to do, isn't it, Miss Mepstead? And also tells the appellant, which is unusual, to tell the appellant, look, this is the strategy that your representative is deploying, and I've given you a warning that I think it's a bad strategy, and I'm concerned about it. I think it does give rise for concern that the judge is saying that right at the outset, before hearing any evidence.
Well, if he doesn't say it at all, he ought to say it at the outset, because it affects what evidence. Would not be too late for Mr. Hussein could have gone away and said, "Oh, I hear what you say. Well, whether you're right or not, I think in the circumstances, I will now call the wife."
Yes.
I think it was. If the judge doesn't take the point at all, you can't criticise him for taking it at the beginning. It gives everyone the chance to adjust their case if they want to.
Yes, of course, he could have taken the point after the appellant's evidence had finished. Of course, this was an unusual case where the wife was sitting next to the appellant. But he could have said, let's have her outside so that we don't lose the opportunity of hearing evidence from her if necessary. And in any event, she couldn't hear the proceedings because I think it's clear from the transcript that...
Well, hang on, that's all. Yes. That's all detail. But the basic point is he knew she was there.
Yes.
And he must have been right, unless the whole concept of an adverse inference was wrong in principle. It must have been right for him to raise the point so that Mr. Hussein could consider whether he wanted to change his mind and call her. No?
My lord, if he's right in substance, if the judge is right in substance that it is open to him to draw an adverse inference, I think it would be harsh to say that it was the wrong point in time to say that. He's told the representative, so the representative is on notice of it. Whether he was right to say that or not is a different matter. It's not really the subject of the appeal.
Okay.
But what is the subject of the appeal is that if he was right to say that, there is a question mark as to why he was not saying the same thing about the lack of evidence from the respondent in relation to 2 visits by immigration officers, which the appellant says resulted in the officers leaving quite satisfied. Certainly nothing arising from the visits that the respondent was relying on to back up the assertion in the case that the marriage was one of convenience. So I think it's the uneven-handed approach that the appellant primarily focuses on. And I think, my lord, if I can find the relevant part of this in my skeleton, it might be a convenient moment to just draw my lord's and my lady's attention to it, but I probably won't be able to find it so quickly. I can't find it. I apologise. I'll come back to it later.
Yeah, okay. Oh, I'm sorry. I'm committing the cardinal sin of raising points before you were going to get to them.
But my lord, no. I think reflecting what we have just said about what happened before the First Tier Tribunal, it is helpful to have interjection so that I understand what it is that I need to address.
Thank you.
My lords and my lady, we were at 191. Going on to 192, the judge has, on a number of occasions, talked about an adverse inference, and he has said that in strong terms. He's also said on a couple of occasions that he would expect the parties to be subject to cross-examination and for the parties to establish that the relationship is genuine. Mr. Hussein has responded and made it clear what his position is. Judge Mills again makes it clear that he's given him an opportunity to rethink his strategy. At 192, you have the exchange where the judge tells Ms. Mepstead, the presenting officer, I'm assuming, though you'll obviously tell me if I'm wrong, that your intended approach in this case, as with other such cases that you will have dealt with, was to question both appellant and spouse about their lives together, to try and establish whether it was genuine or not. Again, this mindset in my submission is wrong. It has already been established that the relationship is not genuine. The respondent has come into court to now make good that assertion based on the evidence that the respondent has already relied upon. We're not looking at this afresh in that sense. Yes, the tribunal is the primary decision maker here, but the evidence concerns a decision that has already been made. Ms. Mepstead says, yes, that is correct and right, so I assume you'll be inviting me to draw an inference like I suggested I might. And Ms. Mepstead says, absolutely. Again, in isolation, that's not the sort of point that would get us to the upper tribunal or to the Court of Appeal, but that is all part of the overall package that a fair-minded observer is observing, and of course part of the overall package when one is assessing whether the hearing as a whole was fair. Then at 193, Judge Mills explains to Mr. Hima, the appellant, that he's surprised that the wife is not giving evidence. And again, it's normally the case in these sorts of appeals that both of you would give evidence. And he tells the appellant that the solicitor has said that this is going to be your strategy, which is fine, and that's your choice. Then at the bottom of 193, the judge sets out the issue before the tribunal, which is whether the marriage is one of convenience or not. And he says himself, there is no dispute beyond that, so it is just that question I have to decide. And the refusal raises 5 key areas where we say there are discrepancies.
Well, the "we" is a bit odd.
It is a bit odd.
I suspect that's to be
it
fair.
might be. It might be a mistake in the transmission.
Yeah, I meant to listen to it when I.
It's not a point that the appellant is taking, and I must say, of course, it is as the appellant's advocate, and not to say that I don't believe the appellant's case or believe in the appellant's case, but of course it's my function to criticise the First Tier Tribunal judge. That is not to say that the appellant is saying that the judge is actually biased. Things went wrong here. And it is right the appellant points out what went wrong, but this isn't a personal attack on the judge or on anybody or the presenting officer. Then, Judge, my Lord, we have on the next page the exchange in relation to the 2017 determination. And Miss Mepstead, about a third of the way through, refers to the 2017 determination and wanting the judge's permission to submit that document, and she identifies the reason for that. The reason I would like to submit this document is because it sets out clearly the appellant's immigration history, and it is the appellant's immigration history that gave the Secretary of State the reasonable grounds for suspicion that this marriage may be one of convenience. That is consistent with the refusal letter and consistent with what was said earlier in submissions, that is the way that the Secretary of State operates the system of cases where he would carry out a further investigation, because not every marriage ought to be investigated. There has to be a reason for suspecting that it might be one of convenience. And the exchange that follows is, I would submit again, potentially at least appears as though the judge is raising the credibility issue, because Ms. Mepstead is very clear that it's just the immigration history she wants to present before the tribunal, because that is what led to the interview. What Judge Mills says is that set out in the refusal letter, the immigration history. Ms. Mepstead said it is not entirely clear. And then Judge Mills, oh, okay, so this is further evidence relating to his background that you say goes to the question of his reliability as a witness, essentially. And that is not what she had said. In response to that, she says yes. There was then an exchange with Mr. Hussain about this, because Mr. Hussain objects, saying it's very late in the day. Judge Mills says it's necessary for me to consider it, given that it is a previous judicial finding on him as an individual. And Mr. Hussain makes the point that is made in this appeal at the bottom of 194 and the top of 195, that there is really no relevance because it hasn't been relied upon to challenge credibility. The immigration history is not in dispute. And therefore, what is the point of having this determination in? The focus should be on the reasons that are set out in the refusal.
The risk of putting to a point I've put already, suppose that the broad point you make is correct and that the focus should be on the 5 reasons given in the refusal letter. But for the FTT, in deciding whether those 5 discrepancies, let's call them that, are innocent or sinister, surely it's relevant to have in mind the immigration background, insofar as it shows that he's someone who may practice deception in order to get an immigration advantage.
My Lord, again, I do not say that it would not be relevant in this case or in other cases. Everything depends on the facts. But
Yes,
the factual circumstance here is that the respondent has never relied upon it.
Yeah.
And that's the point that the appellant makes.
Yeah.
And you can see then that Judge Mills at the bottom of 195 talks about struggling to see why the determination is not being relevant. And again, then, we have what could be perceived as the judge putting words into the presenting officer's mouth at the bottom of 195, but it may say, and I dare say this is the reason Miss Mepstead wants to put it in and rely on it, but she's already said why she wants to put it in and rely on it. It may say the appellant is a liar. The appellant has misled the Secretary of State. The appellant told untruths in court. And that is going to be very relevant to me, is it not? And it doesn't actually say that, but the fact that the judge is saying that it might say that, and nobody has suggested that it does, again, in my submission, gives an appearance to a fair-minded observer that there is a little bit of an unbalance in the way that the judge is approaching this appeal. And then at the bottom of 196, after it has been decided that the determination will be emailed and Mr. Hussain will get a chance to read it, Mr. Hussain again makes the point that he would like to know exactly why Miss Mepstead is relying on it. Is it just for the immigration background, or is there anything further that Miss Mepstead would want to rely on from that decision? And Miss Mepstead's first answer is, it's the immigration history I'm relying on. Mr. Hussain says then, and obviously the judge has hinted about credibility, so is it the presenting officer's position that this decision alters the appellant's credibility, or essentially his credibility will be assessed on the evidence he provided today? And Miss Mepstead's answer is, it does affect the appellant's credibility. Essentially, the refusal was under paragraph 32011 on the basis the appellant has contrived in significant ways to frustrate the immigration law. So that is, again, saying it affects credibility, but by reference to the immigration history, which is not in dispute and which the appellant does not run away from. There is nothing there that suggests that there is any question mark as to whether the appellant was genuinely married previously, and whether that relationship, he was married, but whether that relationship was genuine or not. And it is, in my submission, also interesting that it's only after clarification is sought and Mr. Hussain puts it to Miss Mepstead that the judge has hinted that credibility might also be an issue, that she says, yes, credibility is also an issue, but then confines it to the immigration history, nothing more than that. We then, my lords, my lady, have the beginning of the hearing after a break. Examination in chief begins at the bottom of, or halfway down, 198. And then at 199 we have the exchange where Mr. Hussain asks about the 2019 visit, and the answer given by the appellant is they checked the property, they spoke with my wife. Sorry, this is in relation to the recent visit. So we asked about the 2019, then there's the recent visit. They checked the property, they spoke with my wife.
Sorry, which page are we on?
199.
Yeah, thank you.
They checked the property, spoke with my wife, checked where we live, they checked my clothes, her clothes. I was with my brother just 5 minutes away, and my wife told them I will call him to come. But they said, do not worry, do not bother, you do not need to call him. So they stayed like 10 minutes and they go. Now at the time, of course, the judge did not have access to any evidence from those visits. But we now know that that account of what happened at that visit is broadly accurate. The evidence we have does not tell us anything about the exchange with the wife, so we don't have evidence to corroborate what she says in that he's 5 minutes away, we'll call him, and they say don't bother. But everything else is consistent with the evidence that was before the upper tribunal. You then, at 200, halfway down the page, just at the end of examination in chief, have Mr. Hussain addressing the issue that Miss Mepstead raised about the immigration history. He asked, so basically, Home Office have today produced an appeal document which shows that you have made asylum claim in UK. Can you tell us why did you do this back in 2001 or 2004 when this happened? So he's addressing the immigration history because that is what Miss Mepstead has identified as being something that affects his credibility. And then he confirms that when your appeal got refused, you left the UK at your own cost. He says, yes, I did that in December 2014. He says, I got some wrong advice. I apologise for what happened in the past, and it's then left there. Then at the bottom of 200, you have the cross-examination by Miss Mepstead. That cross-examination is focused on the visit in 2021. As a consequence of that, you have Mr. Hussain saying that I've got evidence of it. At the bottom at 201, Judge Mills is getting a little bit irate as to why he did not raise this at the outset. Then at the top of 202, he reiterates, I'm extremely displeased that you are seeking to admit something by examination in chief. When we have already delayed the hearing for the best part of an hour, in order for you to look at a document that you should have already seen yourself. Now that, again, I would submit is uneven-handed, because the delay was caused by the presenting officer producing a document, and she apologised for that late. It's not something that has been provided in the respondent's bundle or referred to in the refusal letter. The judge.
Hang on, sorry, I'm across. What Ms. Mepstead had been late in producing was the previous FTT judgment.
That's right.
And that's what you're talking. But that hadn't caused.
What
was the delay you're referring to?
The delay is when it was emailed to Mr. Hussain and he had time to then read it.
Oh, I see, the adjournment
Yes.
during the hearing. Yes, I see.
So the delay was caused by the production of the document late by the presenting officer. But the judge here is saying that he's very displeased with Mr. Hussain because he's delaying matters further, having already been at fault for delaying the hearing previously, because he's saying you should have already read that determination, and that we say is that is clearly unfair. I think Judge Bruce also accepted that was unfair, but it demonstrates an uneven-handed approach between the parties, and this is again relevant to appearances because we have the fair-minded observer observing what is going on, and the fair-minded observer who's not making judgments about the substance of what is going on. He's just observing, and it is appearing, I would submit, to an observer that there is an imbalance between the way that the judge is treating the respondent's representative and the way that the judge is treating the appellant's representative.
So you're not at any rate in this context, at this point in the hearing, making any point that the judge doesn't seem to be upset that the Home Office didn't produce this document.
That is coming, my lord. Yes,
I thought it might be. Right.
But my lord can see that the focus here is entirely on the representatives, and there is an imbalance in the way that they are being dealt with. Ms. Mepstead does not object to the document being admitted, so it is admitted. And then there is some time for the parties to look at the document, and there are some difficulties with the connection. And then the cross-examination continues on page 204. She asks about the entry in 2017. And again, her point about it, this is the way she's putting the case, is the immigration history. So the 2017 entry, she says, was an illegal entry. And that, no doubt, is the context of the 2017 determination, because it shows that the appeal was dismissed, and yet he entered the UK illegally after that. She does not ask any other questions about the 2017 determination or the previous marriage. She asks a question about why the appellant has not provided supporting evidence from anybody else. The judge answers, sorry, not the judge, the appellant answers, why do I need to? Judge Mills, so is the answer to the question you did not think you needed to? Appellant doesn't understand. He asks again, and the appellant answers, yes, it is right. I don't believe I need to, because in any event, no one's going to believe me. So the clarification that the judge says he seeks later on has already been clarified during cross-examination. This is why I'm not calling any further evidence. And we'll come on to the upper tribunal's determination, but Judge Bruce accepts that this was not something that needed clarification, and no doubt that is why Ms. Mepstead only asked one question on it, because she knew the strategy, she had the answer, she'd made her point, and she completes her cross-examination there. You then have at 205 the beginning of questions by Judge Mills, and he starts with the 2017 determination of the former wife. That questioning is something that was not subject to criticism by Judge Bruce, and was not subject to criticism by Lady Justice Lang in granting permission. I would ask my lords and my lady to look at it very carefully in the context of what is happening overall. And certainly what one can see is that even if that question might have just been neutral, although one wonders why there was any need for clarification when it's simply not relevant to the issue that the judge has to decide, and there's no issue taken in relation to that relationship, it does provide the material for the judge's determination and his conclusion that the previous marriage was also not genuine. And the way that is dealt with is important, both in terms of the presenting officer's submissions on it and the way that the exchange during closing submissions takes place, because there is absolutely no forewarning that the judge is thinking of making a finding that because of that answer, the previous marriage must have been a sham. And then you then have the questions in relation to why people had not attended to give evidence. I'm not going to take my lords and my lady through it, because Judge Bruce goes through it, and Judge Bruce clearly finds that that question was inappropriate, and we say it really amounts to cross-examination. The real sort of smoking gun on it being cross-examination is that those points are then relied upon by Ms. Mepstead in her closing submissions. The fact that X, Y, and Z person did not attend and could have attended. That information was simply not elicited in cross-examination. At 207, you then have Mr. Hussain objecting to the line of questioning. And in assessing the response to that, I think it is important to bear in mind, and I'm sure the fair-minded observer would bear this in mind, that at this point at a hearing, the representative is in a very tricky and difficult situation. The representative does not want to upset the judge because the judge is going to make the decision, and obviously it's a serious matter to say that the judge is proceeding in an inappropriate manner. But the representative must do that, because if he doesn't do that, and if that questioning is inappropriate and results in a dismissal, it's going to be difficult to take that point later. That's his duty to his client, to raise that, and his duty to the court and to the proceedings. And in my submission, he does it quite bluntly, but my lords and my lady will have heard the recording. It isn't in any way rude or aggressive. The response from the judge is very colourful and animated, because he clearly takes offence at the objection. But one, as a judge, he would expect that a representative is going to say that and do that if that is what he thinks. It's a contentious part of the overall appeals process. There are a number of upper tribunal determinations on it, and all of them say that the representative must make the point. And so his response is initially, you're not doing your client any favours with your behaviour today, I can tell you that much. The presenting officer asked why no witnesses had come. The answer was, why should I? Well, that is not a good answer, is it? That is not the sort of response one would expect from an impartial judge at that point. And if he doesn't consider that it's a good answer, it's certainly not his role to follow it up, to demonstrate exactly why it's not a good answer, and to demonstrate exactly all the ways in which it is not a good answer. That's the presenting officer's role, and that's her job. And if she's chosen not to do it, that is the way the cards fall in an adversarial system. And he says, that is clarification, not cross-examination, Mr. Hussain. You should know better than to accuse me of cross-examining. And then he says, you're welcome to apologise. Again, that is really not appropriate in my submission when a representative is just doing his job. And he's not being rude. Of course, if he'd been rude or said something inappropriate, one can accept that a judge might feel that an apology ought to be forthcoming. But nothing like that has happened. And my lords and my lady have the recording. And then he says, okay, you're not apologising. And again reiterates, you're not doing your client any favours at all, Mr. Hussain. I will carry on with my perfectly legitimate line of clarificatory questions, again underlying the irritation that he's clearly feeling at that point. And that exchange, my lord and my lady, in my submission, is unfortunate. The appearance of that to a fair-minded observer is not positive at all. And it suggests that by this point in time, the relationship between the judge and Mr. Hussain has become very fractious. But in my submission, for no reason that one can lay at the door of Mr. Hussain. His presentation of the case has been very clear, and his attitude towards the judge in my submission has been very respectful throughout. Of course, there will be differences of opinion between judges and representatives, but that is not any reason for this sort of exchange to take place. And the appearance in my submission is not good at all.
Perhaps I should just say, it had occurred to me just before the hearing, but again, the kinds of points you're making now remind me of it again, that there is a decision of this court called In Re AZ, a child. I don't know whether you're aware of it, but the neutral citation is 2022 EWCA Civ 911, in which a rather similar episode occurred. I think when you look at the detail, it's all different, but because of that, we made some general observations. It might just be worth, counsel on both sides, just having looked it over the short adjournment, because there's some general observations about this situation. I'm not suggesting it gives us the answer to this case, but it's not impossible. We might refer to it in our judgment, so we ought to at least give you the opportunity to have a look at it.
I will. I'm grateful for that.
But don't feel obliged to, but just look at it so you're not taken by surprise. Okay.
You then have, my lords and my lady, the submissions on the part of the presenting officer at 2:08, and I just wanted to highlight a few things in there. In the second paragraph of the submissions, she refers to the 2017 determination and reiterates that those are reasonable grounds for doubting the appellant's intentions. And then in the next paragraph, she says, the responses to the interview questions in my submission again do suggest that this is indeed a marriage of convenience. I rely upon the issues which are raised within the reasons for refusal letter and the interview summary sheet. And I would also place reliance upon the response to the skeleton argument. But that in my submission is consistent with the way that the appellant understood the case being put, which is not that there was any reliance on the 2017 determination for assessment of the relationship. That is the gateway to the interview and the investigation, and the reliance continues to be on the reasons given the refusal, which is the 5 areas, and Ms. Mepstead says that those are sufficient to discharge the burden on the respondent.
And the response to the skeleton argument is what's elsewhere called the review document.
My lord, yes. And my lord has already observed that Ms. Mepstead, in making the submission, did not in fact challenge any of the appellant's explanations in his witness statement as to those.
Yes, that's not quite fair. I mean, she
In
challenged them in
cross-examination.
the sense that they were, but
Yes.
she didn't make any oral submissions about them, nor, which was actually I think the point I made, did she cross-examine about them.
That was the point, my lord, I was trying to make. She didn't
Yes.
challenge it in cross-examination.
Yes, I see. Yes.
You then have, in the penultimate paragraph on that page, again, this corruption, I would say, of the idea of what is actually happening at the First Tier Tribunal, which is that it is the respondent that has to prove his case. They had a further opportunity to demonstrate that their marriage was a genuine one not of convenience, and have their evidence tested by cross-examination, and they have chosen not to do so. That, in my submission, is not an appropriate matter for a judge to take into account in deciding whether the burden of proof has been discharged, because the burden rests upon the respondent. Any lack of evidence should be held at the door of the respondent, especially when the appellant and his wife have already subjected themselves to extensive questioning. If they had not attended the interview and were simply avoiding any scrutiny at all, this would be a legitimate point. But in circumstances where they've both been interviewed extensively and the respondent has said, these are the problems, in my submission, it's not appropriate to say that the appellant should be criticised because he did not subject himself and his wife to a further test as to whether they are giving consistent answers.
That may be right, but we're here to decide whether this was a fair hearing.
My lord, yes.
The fact that the presenting officer made a duff point
Yes.
doesn't render the hearing unfair, does
My
it?
lord, no, I don't say that, but I say that because it's a theme that's running through the proceedings with the judge as well, making that
Well,
same point.
we're concerned with the judge, aren't we?
Yes, yes, my lord. And then you have, in the next paragraph, the submission with respect to the lack of evidence from anybody else. And that then relies upon what I would term the cross-examination by the judge to make the points about all the people that could have come but did not come. And that is it. Judge Mills then asks about the visit from the immigration officers, and Miss Mepstead responds to that and says she accepts that there was a 2021 visit. She cannot say anything about the 2019 visit. She says that...
So where are you reading? It's actually, yeah, no, I've got it by the whole bunch, yeah.
Yes. And she says that she was unable to find anything on the systems that she has access to. She says very clearly at 209, I do not, of course, have access to everything, but I did check the SID records and I could find no reference to it.
It's odd, it really points to alert Miss Anderson to. Odd that she says, as if it was obvious, I don't have access to everything. You'd thought a Home Office presenting officer would have access to the entire file before coming to a hearing like this.
My Lord, yes, and I think the way I would put it is that you would have thought that the respondent would have provided the respondent, the presenting officer, with everything.
Oh yes, well, you're quite right. I didn't mean to say Miss Mepstead personally, but I mean the system should ensure that she got everything in the file.
Absolutely.
And then she can make her own judgment what was relevant. I mean, there'd be a lot of old stuff which wouldn't be relevant or was sufficiently summarised in the earlier decision. But at least she would, and she would certainly, in principle, you'd expect to have seen the visits.
My Lord, yes. And I would make 2 points about that. First of all, the 2019 visit was referred to in the witness statement.
Yeah, well, of course, yes.
And therefore, that is something that the respondent should have said something about.
Quite.
And not saying anything about it, in a sense, well, it certainly did mislead the First Tier Tribunal. Whether the judge approached this properly or not is a different matter, but the reality is that he accepted the explanation from Miss Mepstead, misunderstood it as thinking she checked all the systems and it wasn't there, and simply accepted that explanation without there being anything formally from the respondent addressing the assertion by the appellant. That is, in my submission, a matter that gives cause for concern, because the appellant has clearly set out in the witness statement what happened in 2019, and there's no evidence the other way apart from Miss Mepstead's submissions on the point. As far as 2021 is concerned, the judge also knows at this point that Miss Mepstead found no trace of that on the system either, but that she now accepts that it took place because he has evidence in relation to that.
Yeah.
Had he been behaving in a clear-headed and even-handed manner, and I think this is an overlap between him, I can't remember the phrase, but I think it's descending into the arena. Yeah, that's the one. Descending into the arena. This is a byproduct and a consequence of him descending into the arena, that his thinking has now, in my submission, become, I think this is another phrase that I know, clouded by the dust of conflict, I think is what is said in the authorities. Because had he been thinking clearly here, he would have been asking Miss Mepstead why there is nothing on the system with respect to the 2021 visit when we know it happened, and in those circumstances, how she can be confident there was nothing in the 2019 visit that was asserted by the appellant. But he doesn't do either. There is absolutely no criticism of Miss Mepstead or the respondent, and a fair-minded observer would contrast that with the way that Mr. Hussain has been dealt with earlier and subsequently. So that exchange takes place, and there is then the end of Miss Mepstead's submissions, and there is absolutely nothing said by Miss Mepstead in relation to the exchange with the judge, between the judge and the appellant, about him not going to live with his wife in 2017. So she is not relying on that in any way to suggest that the previous relationship is now in doubt. Mr. Hussain then starts his submissions, and he starts his submissions by politely telling the judge that he ought not to have a closed mind, that what he said at the start of the hearing ought not to be the end of the matter. He ought to look at the evidence, listen to the submissions, and make his own mind up. If we go to 211, and the lengthy paragraph from Mr. Hussain, he again reiterates his strategy, which is set out in the appeal skeleton, focusing on the 5 areas identified in the refusal. And at the end of that paragraph, he also makes the point that an inference should be drawn against the Secretary of State for failure to produce evidence in relation to the 2 visits. And then at the bottom of 211, Judge Mills tells Mr. Hussain, you seem to be getting quite irate. And then again, as you get irate, you are talking very quickly. And my lords and my lady have heard the exchange. I would politely ask that you perhaps listen to it again. In my submission, he is not getting irate at all. His submissions are continuing in the same way that they have continued throughout the hearing. And a fair-minded observer would be aware of that. And then Judge Mills, continuing on to page 212, understands that Mr. Hussein's point is that I only have to focus on the 5 issues. And then there is the exchange about the Secretary of State not providing evidence to the tribunal. And halfway down 212 again, Judge Mills is getting irate. You've already accused me of being impartial in this case today. You've already accused me of cross-examining your client. Are you now accusing Miss Mepstead of deliberately concealing evidence from the tribunal? Is that what you are doing? Are you quite sure that is not what you are doing? Yes, I'm quite sure that is not what I'm doing. I'm pleased to hear it. That's an unfortunate exchange again. I think it tells us something about the way that this hearing has developed. The relationship is obviously now completely fractured between the judge and the representative. Mr. Hussein then, and I would say to his credit, ploughs on with his submissions, again in an even tone, and makes the points that the inference to be drawn, and this is at the top of 213, needs to reflect what the party bearing the burden of proof has done in this appeal. That investigations have been conducted beyond the interview, and that those documents have not been put before the tribunal, or any information in relation to it has not been put before the tribunal. And then Judge Mills, in response to that, talks about the evidence that we have in relation to the 2 visits. And again, he's focusing simply on the evidence that he has before him, not on what evidence could and should have been presented to him from the respondent who bears the burden of proof. And in the second paragraph of his lengthy passage from him, there's towards the end of that paragraph, so you are telling me it is clear that the Secretary of State has conducted further investigations. It is not clear to me on the evidence you have produced. It is not clear to me at all that that is the case. And of course, what he should have been saying is, Miss Mepstead, we know that there was 1 visit that doesn't appear in your systems. Why did I not have information in relation to that visit? And how can I be sure that the 2019 visit didn't take place? Should I not be drawing an adverse inference against the respondent in all the circumstances? I'm not saying that he ultimately should have done that, but that exchange doesn't take place, that thought process doesn't take place, and that appears in my submission to a fair-minded observer as an uneven-handed approach to the parties. He then, after continuing with his point, Mr. Hussein tries to object, and the judge, and I think, again, this reflects his frustration with the strategy. And I think it's an unfair frustration. You might disagree with it, and it might be that 99% of practitioners might disagree with it. But that doesn't mean that you take your frustration out on the appellant and the representative because the strategy is being pursued that you don't agree with. And he says, you can say that the burden is on the Secretary of State as much as you like.
So where are we reading from now?
The top of 213.
Oh, yeah, thank you.
I think you mean 214.
Sorry, my note was right. 214, top of 214. You can say that, yes. And Mr. Hussein tries to interject, the burden is on the Secretary of State as much as you like. Do you really think, as a legal professional, that you have approached this case in the appropriate way, Mr. Hussein? And Mr. Hussein, again, in my submission, commendably calm. I must say, I would hope that in this circumstance, I would be as calm, as lucid as he remains, because he does make his points, and he makes them well. What I meant further down the page is that the question that has come in the course of this hearing.
Well, I think before we get there, Mr. Hussain attempts to say, well, I haven't said the Secretary of State's concealed evidence, and Judge Mills says, well, you did say that.
My lady, yes. Yes. And I think the submission that's made in the skeleton is that what has happened here, I fear, is that the animus that has now been created with Mr. Hussain's strategy and Mr. Hussain and the judge is spilling over into the substance of the decision. That is what Judge Bruce also says in her determination, that there is a risk that a fair-minded observer would consider that. My submission is that she didn't go far enough. That is clearly what a fair-minded observer would deduce from what is being seen here, the appearance of it. And when one looks at the substance of the determination, and one doesn't really look at the substance to address the fairness of the hearing, but it's clear that that has infected Judge Mills's thinking. And it is clear that the fairness of the proceedings have been undermined, the integrity has been undermined because of the descent into the arena and the conflict between Judge Mills and the strategy, and by association, Mr. Hussain. And Mr. Hussain then sets out in my submission very clearly what his approach is, the strategy again, why he is saying that it is the Secretary of State that bears the burden and therefore it was not for him to adduce evidence. And then he also says that there was no challenge to any of the explanations in cross-examination. I'll ask you to note that. He goes through all of the points that he has, that the appellant has made in the witness statement. He again at the bottom of 215 says this has not been challenged in cross-examination, the explanation. And then at the bottom of 216, Mr. Hussain's last paragraph from his lengthy submission makes again the point about the strategy, that an appellant cannot be expected to simply address anything and everything. The issues are framed between the parties. It is those issues that are in issue before the tribunal, and the judge must adjudicate between the parties based on those issues that have been framed by the parties to the appeal. Then at 216...
Do you mean 216?
At the bottom of 216, my lord.
I see, right.
If the burden on him was an evidential burden, he satisfies the evidential burden. And then he talks about the 2017 determination. And he says, nowhere in that judgment has the court found the appellant or his wife not to be a credible witness. And then it has to be noted that despite the immigration history, the Home Office and the court found the marriage inaudible. And I think the point he's making is that the marriage was found accepted to be genuine. And that is it as far as the exchange is concerned in submissions, closing submissions. But what I would say at this point is that it is very clear that in a case where the judge was very forthright in giving the appellant notice at the start of the hearing about his concerns with respect to the strategy, and in a case where it is perfectly clear by the end of closing submissions what the appellant understands the case he has to meet to be, the judge does not give him any opportunity to deal with the two issues that he deals with in his determination and finds weigh heavily in the overall assessment of the appeal. And that is his conclusion that the 2017, or the marriage that was the subject of the 2017 determination, was a sham. He doesn't bring that to his attention despite Mr. Hussain making the submission that there was never any doubt. And he does not raise with him that, look, there are other answers in interview that are inconsistent or that are not, don't demonstrate a marriage that is a relationship that is genuine. and he relies on those to some extent in his determination. But there's no opportunity for the appellant to deal with any of that in submissions because the judge doesn't give him any opportunity to do that. And it simply isn't the way that the case was put by the respondent, and it's entirely inconsistent with the way that the appellant has clearly set out his case in closing submissions. Because it's the next document, can I just take my lords and my lady to the 2017 determination?
Yeah.
And so 221, paragraph 7 of the determination, subparagraph 4, 7.4, the judge sets out the background of the application by the appellant on the basis of his relationship with the previous wife. That was made on the 3rd of October 2012. And at subparagraph 6, which is at the top of page 222, Judge Shiner notes that the refusal of that application resulted in an appeal before First Tier Tribunal Judge Omotosho, and he notes that the judge heard evidence from the appellant and the sponsor. And then at 7, it is said, and I accept that the appellant then left voluntarily in 2014, and that thereafter the appellant made the application sometime in early 2015, which is the subject of the appeal, which is heard by the judge in 2017. So the relationship with the previous wife dates back to 2012, obviously ended in 2017, so it's a lengthy relationship, was tested at a previous hearing. The judge found that the relationship was genuine and that wasn't challenged subsequently, and the judge found...
Sorry, I'm just looking at the chronology right. The relationship goes back to 2012, you say.
Yes.
And you said it went on to 2017. It didn't go on in the sense of cohabitation after 2014, is it? Because he left in December 2014.
My lord, that is right. So there was around 2 years of cohabitation in the UK.
Yes.
That period tested before a judge, and the judge finds in the appellant's favour, and then he leaves. But as my lord will see later on in the determination, the context of this decision was that the wife had visited the appellant 4 times in the intervening period whilst he was in Albania.
Thank you. Sorry. Well, carry on. Yeah.
Yeah. So at paragraph 20 of that determination at 225, the judge heard evidence from the sponsor and she was available for cross-examination. In fact, she was asked very few questions. At 24, paragraph 24 at the bottom of that page, you can see that the counsel for the appellant referred the judge to the decision of Judge Omotosho. You then have the submission on behalf of the appellant. At paragraph 26, it is said that it is accepted that the sponsor and the appellant are married and in a genuine relationship, and reference is made to the sponsor visiting the appellant 4 times whilst he has been waiting for this appeal. At 28, paragraph 28, about 8 lines down, the judge notes that he was reminded that the respondent does not take issue with the genuineness of the relationship.
Which paragraph we in? Oh, yeah, I've got it. Yep, thank you.
And then the last sentence of that paragraph, the judge was reminded that the appellant's last aggravating factor, which resulted in a breach of the immigration rules, occurred in 2008, and the appellant has been seeking since 2012 to regularise his position. Then at paragraph 35, you have the judge's findings of fact and credibility. At 35, in the second sentence, they are in a genuine relationship. The sponsor has visited the appellant 4 times since the appellant returned to Albania in December 2014. And then at the bottom of 228 at paragraph 39, I accept the following matters in the appellant's favour. That gives some context to the poor immigration history. and then at 39 subparagraph 6, the appellant has been in a relationship, is married and has maintained that relationship since 2012, and whilst being separated over the last 2 years. Sorry, 2011, so it's actually an older relationship than the date of application. At 42, in his reasoning, towards the end of the paragraph, I have given particular weight to the appellant's relationship with the sponsor and his return to Albania. I note further in this regard the conclusion made by Judge Omatosho to the effect that she could find no reason to believe that the sponsor would be unable to make the transition to join the appellant in Albania. At 45, paragraph 45, I accept that the appellant and sponsor are married and in a genuine relationship. So Judge Shiner's determination doesn't simply say this wasn't an issue before me. It sets out the background in some detail, and that background is a lengthy background. And that is why, again, a fair-minded observer would be aware of all of this. And the question would arise on the basis of the answer to one question, which is not followed up by a challenge. The appellant is not given an opportunity to answer the very serious allegation that this marriage was therefore not genuine. The judge hears no submissions on it because the appellant's representative has no notice that this is an issue. The judge simply jumps to the conclusion that that one answer means that the relationship was never genuine. And that also leads to the unbalanced approach. He says in his determination and during the course of the hearing that the previous determination is important because it's my starting point. And I must take into account what it says about the poor immigration history. But he clearly did not treat it properly as his starting point for the assessment of the previous relationship. He simply jumped to the conclusion based on the answer that this was a sham marriage. What he should have done, if he was following the same approach, is said, well, Judge Shiner's determination is my starting point. This is everything that he said about the relationship. This is what I've heard today. And I'm therefore concluding that the relationship is a sham, but that process simply didn't happen. I think next, my lords and my lady, is the FTT determination. And I'm mindful that it's now 10 past 12. I'm going to try and speed up because I know that my lords and my lady want to finish to then. My learned friend obviously has to respond.
Well, don't speed up unnecessarily. I mean, I think that exercise has actually been very helpful. Will enable you to be a lot quicker. But
I'm grateful.
Don't forbear to say anything if you do need to say.
I think the First Tier Tribunal determination itself potentially doesn't need to be examined in so much detail because, as my lord has observed, it's not the substance of the decision that's under challenge. The challenge is to the integrity of the proceedings. The judge sets out the way the hearing unfolded at paragraphs 5 onwards of the determination. This is page 174. The statement at paragraph 9 that Miss Mepstead stated that she had intended to test the relationship by asking questions of both husband and wife about their relationship in the normal way and would ask me to draw adverse inferences by the failure to tender Miss Russo for a cross-examination doesn't perhaps properly reflect what actually happened at the hearing. Yes, she did say that she was going to adopt the approach, but those are the words of Judge Mills and not Miss Mepstead. At paragraph 17, the judge sets out the submissions of Miss Mepstead. And it's important in my submission to note here, because of what Judge Bruce says in her determination, that Judge Mills himself did not understand Miss Mepstead to be saying anything about the 2017 determination and the marriage issue. And there isn't really, in my submission, in those submissions that the judge has summarised, so his understanding of the point made by Miss Mepstead, anything other than the submission that the immigration history undermines his credibility as a witness. At paragraph 35, the judge says that his starting point must be that the appellant is not a reliable or trustworthy person, and I find that I cannot take his word at face value. And then he says this should have been obvious to Mr. Hussain. In my submission, that is an unfair characterization of the case that was put by the respondent against the appellant, and it is also an unfair characterization of the previous determinations, because clearly both Judge Omotosho and Judge Shiner accepted the appellant's evidence in relation to his previous relationship. So he can't have been somebody that simply could not have been believed about anything. It is true, and the appellant accepts that the immigration history is poor. He doesn't shy away from that. That is
not just poor, but involves deception.
My lord, it does. And that is why I think it is also important to bear in mind the findings of Judge Shiner as to when the last deception took place and his explanation for them. So they are fairly historical. I accept that post-2017 there's a further issue with his credibility and with his conduct, because he enters the UK illegally. But the tribunal will often be dealing with appellants and witnesses that have this background. One cannot simply say that because there is an adverse background, the starting point is the appellant is not a reliable or trustworthy person, and I cannot take his word at face value, especially when two previous judges have accepted his evidence. And it is of note that Judge Shiner's determination is not a commentary on the appellant's evidence at that point. It's an assessment of where the balance lies given the immigration history. And even if the judge was right to say that that should be his starting point, it certainly, in my submission, would not be fair to say that Mr. Hussain should have been on notice of all these things. At paragraph 36, one can see from the first sentence that the judge is placing a great deal of weight on his assessment of the 2017 issue, the entry into the UK, the breakdown of the previous relationship, and his conclusion, which is set out at paragraph 37, that the relationship was nothing more than an attempt to obtain immigration status by whatever means possible. So this is a matter that the judge placed significant reliance on in his findings. At 41 to 43, you have the judge placing reliance on the questions that he has identified that have not been identified by the respondent or been communicated to the appellant, so he didn't have an opportunity to address this in evidence or in submissions. The additional issues. And at 44, he says that cumulatively they add up to a significant lack of knowledge about each other despite claiming to have lived together for 18 months. Now again, the substance of the decision is not a matter that the court will be adjudicating upon, but to make good the point that the failure to give the appellant an opportunity to deal with this undermines the integrity of the process, the appellant has, in the schedule to the skeleton argument, set out why these issues are not potentially as serious as they might have appeared to Judge Mills and could have been addressed, and he might have been satisfied in relation to some of them, if not all of them, if the appellant had been given an opportunity. At 54, he then refers to two other discrepancies. And at 55, he himself recognises that the difficulty in that Mr. Hussain and the appellant have not had an opportunity to address this. So he says that I can't give significant weight to these points, but I can give some weight to them given that Mr. Hussain has had sight of the interview transcript since at least September 7th, 2020, had ample time to go through the record, to note what are clear and obvious issues and to deal with them in the appellant's witness statement. That really is, in my submission, completely ignores the way in which the case was clearly put by the appellant. It also, again, demonstrates the uneven-handed way that the judge dealt with the appellant and his representative in relation to what they should have been on notice of, and the way that he dealt with the respondent's representative and the respondent with respect to the two visits. At 58 and 59, the judge talks about the stronger evidence that would have been available. And at 59, in relation to the 2021 visit, he again reinforces it's even more surprising that she was not called to give evidence because she was the person that was there in the 2021 visit. He makes reference again at 60 to the fact that the person who was present, Ms. Russo, was not called to give evidence about this matter. And he says, I can't place any real weight on the appellant's second-hand account of this visit without taking any account of the fact that the appellant's evidence had been found to be true with respect to the 2021 visit, and that the 2019 visit, in relation to which the appellant gave evidence, had not been addressed at all by the respondent. And there's no reason to suppose that it would not have taken place. At 61, he remarks about the COVID lockdown and that the fact that the appellant was not present at the address suggests that that actually supports the respondent's case. But again, this has not been put to him. The COVID lockdown was something that was varying throughout. There were various restrictions in place throughout, and there is absolutely no suggestion or no articulation by the judge or the respondent as to how it is said that the appellant's behaviour on that date was in breach of the lockdown. It's just a general statement without the appellant being given any notice of the issue, no identification of the regulations and restrictions in place at the time, which everyone was having difficulty understanding, top to bottom, and no suggestion that he's been given an opportunity to deal with it. And then at 63, you have, I think, a clear statement from the judge as to what has happened here. His animus with the strategy and with the respondent, he clearly says himself, has had no small part to play in the outcome of this appeal. And the fact that this has made its way into the determination, in my submission, shows how big a part this had now become, how big an issue it had become in the judge's mind. If I then take my lords and my lady to the upper tribunal determination, that's at 117. At paragraph 3, you have the judge setting out the issues before the tribunal, clearly whether the judge acted fairly and without bias. At paragraph 13, you have a summary of the issues that have been taken by the appellant. And my lords and my lady will note in the 4th bullet point there is reference to the judge descending into the arena, and in my skeleton I've sought to draw out that point as a distinction from appearance of bias and fairness. Not that it's a separate ground of appeal, but if there has been a descent into the arena, that itself is an extremely serious matter, quite removed from the appearance of it, because it clouds the judge's judgment. And the authorities, I've set out the authorities in the skeleton and what they say about it, but that in itself is an extremely serious matter, and in my submission it is clear when one listens to the hearing and reads the transcript that that is what has happened here. And at 15, just because I know that in the respondent's skeleton it is asserted that the sole ground is bias, you'll note at paragraph 15 that the judge at the upper tribunal clearly says that the submission on behalf of the appellant was that the bias issue could be left to one side and the fairness issue could be dealt with without delving into bias. But the judge felt that the bias was the central issue and that we had to deal with both together. At paragraph 20, you have the account of what happened with the evidence of the 2 visits appearing before the upper tribunal. The summaries of the visits are set out at paragraphs 20 and 21. And you will see that in the last sentence, or the penultimate sentence of paragraph 20, the judge sets out why she was considering the summaries of the visits extracted from the original documents and put into a separate Word document by the presenting officer, because much of the information in the original notes had to be redacted. That was the explanation given. So she only has these summaries. And then at 22, you have an email from the presenting officer which says, as will be made clear, neither of the visits was in any way connected to an assessment of the validity of the marriages. And contrary to claims, neither of the visits made any conclusions that they were satisfied that the marriage was genuine. It is to be noted that the appellant was not present at either of the visits, despite the second visit being undertaken when there was a national lockdown due to COVID restrictions. It is one thing for the tribunal to take account of this information. I don't use the word evidence because we don't actually have the original evidence. What we have is the presenting officer taking information from a document and creating another document. But
yes, so we now have it, but the upper tribunal.
Yes. The relevance of it was to show that the appellant was telling the truth, and to show that the approach of the judge had resulted in him determining the appeal on the basis of a complete misunderstanding as to the factual background and not having the evidence, and that his uneven-handed approach had resulted in him not asking for it, not taking into account that the respondent had not produced it. That was the relevance. There was certainly nothing recorded in the determination where the parties have made submissions as to what the evidence establishes and asking the tribunal to make findings on that evidence. That is an entirely different matter to the issue that the tribunal was concerned with, was whether there was an error of law in the First Tier Tribunal's determination.
Now, I see what you say about that. I must say it struck me somewhat high-handed for Mr. McVitie simply to take it on himself to say bits have to be redacted without saying why.
And there has been recent case law from this court about redactions, and we now have an unredacted version.
Yes. Well, the answer is it's not. I felt obliged to say that because I was troubled by it when I saw it, which was a stage before we'd seen the most recent documents, but it's not, strictly speaking, relevant to the appeal. No,
and if I could, my lord, this is a convenient time, I think, to just have a quick look at the documents, the originals, because what they show, one, I think, without any doubt, the second one, there is a need, I would submit, for further investigation, and that investigation could have taken place and could still take place. But what they show is that what Mr. McVitie said in his email wasn't entirely accurate.
No, well, I thought you'd be saying that.
If I could take my lords and my lady to the 2019 visit document. first page, you will see that there is halfway down the page on the left-hand side, Intel source type and Intel source subtype. And the type is from another government department. The subtype is Registrar Section 24 report. That is a notification from a registrar that he or she considers that this relationship might not be genuine. So it clearly is inconsistent with what is said by Mr. McVitie in this article, which is that neither of the visits were in any way connected to an assessment of the validity of the marriages. And my submission is that cannot be right in relation to the 2019 visit.
Right.
And in relation to the 2020 visit, sorry, the 2021 visit, that document clearly shows that there are all sorts of allegations being made about this address. And because
I read that last night and I was just looking for it this morning. I couldn't lay my hands on it. Do you have a spare copy of the 2021? Hang on, while you're looking for it, I found it now.
I'm good for mine.
Yes, sorry. My lord was about to ask a question.
Well, no, I wasn't. I was going to remind my lord of what the context was.
Yes, my lord, the context is, as ever with this case, colourful. All sorts of allegations being made by neighbours. But what you do have by 2021 is, and I think this comes, well, if I could just work through the document from page 1, you'll see that the lead agency is the police. And then you have an overview of Intel. And that overview of Intel clearly, in the first paragraph, refers to the reason for the referral. In the second paragraph, starts looking at the people living at the address, identify the appellant, and in the last two sentences, make reference to the fact that there was a suspicion that the relationship was not genuine, and that he currently has an appeal outstanding against this refusal. You then, on the second page, additional information, you have reference to the previous visit in November 2019, and that Hima was the target of that visit. So the appellant again was the target of that visit.
Can you just help us? It may have been apparent from, I'd followed through the email chain. These were only produced very shortly before this hearing.
My lord, yes.
Were they produced because they were being pressed for, or were they produced spontaneously by the Home Office?
They were the appellant's representatives were pressing for them because there was clearly
I see.
A difference of opinion as to what those visits
But I don't.
related to.
This isn't a matter about which Lady Justice Elizabeth Lang made an application. No. They were just pressing in correspondence, and they in the end decided that they ought to produce them and did.
Yes.
Okay, thank you.
If I could take my lord next to page 7. At the top of that page, the police had clearly been observing this place because I think the allegations had been around for some time, and they confirmed that from their observations they don't believe it to be a brothel, but they wanted to visit to confirm because there are a lot of coming and goings.
Yeah. And
then you have the debrief on that page. And this, it's important to take account of the fact that this is a Home Office document, so it's not a police document. This is produced by the immigration officers. And whilst they've been called in by the police, and the police is the lead agency, the immigration officers have clearly gone into the background of the address from an immigration point of view and have come into this visit with their own set of criteria, parameters, whatever it is. We don't really know because we don't have all of the information. But the debrief in my submission clearly suggests that the focus of the immigration officers was on the fact that there was a pending appeal and an accusation that this relationship was a sham. That is why the immigration officer's debrief has nothing about the actual issue that the police have identified. There's no questions about the comings and goings and the accusation that it's a brothel, etc. It's all about appellant not being present, what they observe, and then the conclusion at the end, target not present, to confirm circumstances in relation to IV's substantive relationship with Rusa. And my submission is that it is unsafe, and it was unsafe for the presenting officer to say to the judge that this also had no bearing on the relationship itself. In relation to this, to be fair to the presenting officer, this part was copied in. So the judge also had this final sentence, but the judge didn't have the full context, and that is unfortunate. But when one looks at both visits, and the second visit has far more detail about what the officers observed, what was said to them, a photo from the wedding day. We don't know whether that photograph was framed and on the wall, so that suggests that it's something of importance, or they just found a photograph in a drawer. We just don't have that information. But to say that these two visits take things nowhere is, in my submission, not correct and unfair. They're not a smoking gun. Again, that the appellant and his wife are in a genuine relationship. They're also not a smoking gun the other way. In fact, what is stated in these visits is consistent with what the appellant has said in evidence before the First Tier Tribunal. It's also consistent with what they say about their relationship. There's nothing inconsistent. And if this material had been before the First Tier Tribunal, the appellant could have made applications to get more evidence.
Well, okay, but it's not a ground of appeal that it wasn't.
No, it's not. I think the point I'm trying to make is that why it affects the integrity of the process, why it renders the proceedings unfair. Because had this material been there, there is so much that the appellant could have done in order to explore it, and of course make submissions in relation to it as to why it supported his case.
Well, I think you can't have it both ways. I quite understand, and it's only been produced very late. It may be that you could say, now I know this, I want to add to my grounds of appeal, but you can't just rely on it as general background.
No,
maybe it's around.
I think the point is the third ground of appeal. So, and I think it's the second one in the chronological ground. It's ground 3.
Yes.
It's about whether the upper tribunal erred in making findings on this evidence, and that's why we say that the findings were erroneous, because they themselves are unsafe and unfair. First of all, the appellant was not on notice that the upper tribunal was going to make findings on the evidence. It wasn't a matter that was related to the grounds before the tribunal. And as Justice Langer set out in the grounds of commission by reference to the relevant case, which is also referred to in the skeleton, there is authority from the Court of Appeal that is not appropriate. What should happen is you find an error of law. If there is an error of law, you go on to decide whether you want to make findings on other evidence. So that structured approach was not followed here. But the unfairness and the unsafeness of the approach is that the judge has made findings on the basis of 2 documents and an email, not seeing the originals, not allowing the appellant any opportunity to make submissions in relation to it or explore the evidence. And that really is ground 3. And it's set out in the skeleton, and I think this completes the submission on it.
I thought ground 3 was the upper tribunal can't engage in this process, full stop, unless it's found an error of law in relation to that part of the case.
My Lord, yes. And
I'm sorry to interrupt. And they didn't do that. No. So to start making findings of fact about it, well, they simply didn't have jurisdiction.
My Lord, yes. That is the simple point.
So what the document says, all very interesting, but it's not actually relevant, is it?
I take my Lord's point, and if my Lord is with me at that point, I don't need to say anything more. But I think what I was trying to do was to show that the error really does lead to substantive concerns as well.
The most you can say is that it is illustrative of the kinds of problems that arise if you embark on the exercise that the tribunal embarked on.
my Lord has said it in a much shorter way and more eloquently, and I'm grateful. That is exactly what I'm trying
With
to
the
say.
sort of debating point that it's not just something I made up, because actually we now know what he did say, but it's got to be put that way.
Yes.
Yeah.
So going back to the determination, and I'm mindful of the time, and I know that in the skeleton I have addressed the difficulties with the upper tribunal's reasoning in some detail. I hope that is helpful and that is clear. And I think overall, if I perhaps it's a convenient moment to take my lords and my lady to the skeleton, so that you have the points that I'm making in relation to it, because I don't think looking through the upper tribunal determination is really going to assist us all that much, particularly bearing in mind the time.
Yes.
And so I've dealt with it, paragraph 21, the fair hearing and apparent bias points together because the points overlap, the submissions I've tried to distinguish them, although there is inevitably overlap between the two. At 21 I've listed the issues that the upper tribunal itself accepted were problematic. And at 23, looking at the reasoning of the upper tribunal, that there was legitimate cause for complaint, but that no error of law has been established such that the decisions should be set aside. It is implicit in that the tribunal was satisfied that there were errors.
Yes.
And I would say that certainly in the context of this appeal and the nature of the issues that have been identified, that the upper tribunal was satisfied that there was unfairness, there were problems with the procedure, but that it could be rescued when looking at the process as a whole. At 24 onwards, the appellant says that the difficulties that the tribunal has identified, the upper tribunal has identified, are serious problems. So they're not just problems, they are serious problems. The first point is the cross-examination of the appellant.
Yes, and these are points you have already made to us very helpfully.
And if I could just emphasise the last sentence of paragraph 26, that one cannot rescue the apparent bias by deciding what the judge actually meant. One has to look at the way it appears to a fair-minded observer. And my submission is that what the upper tribunal did was enter into a substantive assessment of the judge's approach, whether the judge was right in being irritated with the strategy, whether the judge was right that the strategy was misconceived. That's not the point. The appearance of bias is all about appearance, not about substance. Then at paragraph 30 onwards, trying to distill these points into apparent bias and fairness. On apparent bias, the appellant says that at paragraph 39 of its determination, the upper tribunal failed to ask itself and answer the correct question, whether a fair-minded observer, having considered the facts, would conclude that there was a real possibility of bias. It asked and answered a different question, whether the hearing as a whole was fair. So the test that has been applied is wrong, and that in itself is an error. And if that is an error, then this court has to decide whether one just sends this back to the tribunal or one decides it for itself. And this is where my lords and my lady will note that there were protracted discussions between the parties about settlement, and there is a previous skeleton argument on the part of the respondent where the respondent concedes that the application of the test was incorrect. The appellant's point was there's no point sending it back for the whole exercise to be conducted at the tribunal. This court is in just as good a place to conduct the exercise of considering whether the upper tribunal's decision was right or wrong in substance
Yes, but all that was ever on offer in that, not sure how much we need to be concerned with it, was that it should go back to the upper tribunal.
Yes. And the
The alternative, which I imagine is what you're now arguing for, is it should go back to the First Tier Tribunal. Or I haven't picked up, perhaps I haven't read it properly. You're not suggesting we can determine the whole
My Lord, no.
appeal.
Certainly not asking the Court of Appeal to determine the whole appeal.
At one point it looked as though that was the position that your instructions were taking.
At one point it did look at that way, my Lord, I accept that, but I think it was clarified repeatedly. But the difference between the parties' position previously was the respondent considered that the appeal could be allowed sent back without an error of law having been found. So that exercise...
Well, probably, for better or worse, those negotiations went nowhere.
Yes.
So we got to deal with what's before us.
Yes.
Yeah.
And so my submission is that if the court finds that there was an error in the application of the test, the court could either stop there and send it back, or the court could go on and apply the test itself and decide whether there was an error of law in the First Tier Tribunal's determination or not. In doing that, there is nothing stopping the court from going beyond what the upper tribunal found to be the criticisms of the First Tier Tribunal. So the court isn't confined to considering what Judge Bruce found to be problematic. The court can go beyond that.
Yes, I see.
But that, I mean, that in a sense, all very interesting, but doesn't take us anywhere. If we conclude that the upper tribunal judge was wrong, then we have to do something, and we would send it back to the First Tier Tribunal for them to start over.
My Lord, yes, but if
it doesn't really matter whether we say the upper tribunal judge was wrong in finding the things she thought were bad didn't amount to unfairness, or whether we said the upper tribunal judge was even more wrong because she should have found other things.
Absolutely, my Lord.
I mean,
I think ours is a belts and braces. If my lords and my lady find that the judge's findings at the upper tribunal were not sufficient to establish unfairness, then we say that this court is entitled to take into account of other matters that the Judge Bruce did not take into account. But of course, if this court says those findings are enough, then one doesn't have to look at the other.
Well, I think we're all saying the same thing, really, that although we've got to look at the upper tribunal's approach, ultimately this is about whether the FTT acted fairly, and that's where we've been for the first chunk of your submissions, and where you've quite rightly put your focus.
Yes.
So let's push on with this.
But I think I'm happy to say, certainly I would hope to be finished by 1.
Yes.
And I hope that gives us enough time in the afternoon.
I'm sure it will.
So at paragraph 31, I set out where the apparent bias was in 6 numbered points. At paragraphs 32 onwards, I address the upper tribunal's finding that those problems that the upper tribunal accepted don't render the hearing unfair or lead to apparent bias. At 35 onwards, there's reference to the authorities on descending into the arena, and how that in itself is a separate area of serious concern. And at 39, quoting from the authorities, independent of appearances or on what an objective observer of the process might think of it. So one takes away the assessment of whether it was right or wrong, and the appearance on its own, it's extremely serious and is liable to cloud the judge's mind and judgment. And then at 41 onwards, the submissions as to why the hearing was unfair, and the submission made in the grounds of appeal that if it is found that parts of the hearing are unfair, one cannot rescue the process by saying that looking at it overall it was fair. Once any aspect has been identified as being unfair, the entire process is undermined. Of course, my Lord, there will be some cases where there might be a very minor unfairness complained of, but one would expect that such a case would not get permission to appeal, because one cannot simply pick and choose that one statement was unfair.
Yes.
It has to be an unfairness that is...
At one point I thought you were adopting, in your skeleton, a rather extreme position that any single unfairness or change is bound to taint the fairness of the hearing as a whole. I think you would find some resistance from me, and I suspect from my lord and my lady, to that submission. But I think you're making a more modest submission that if there is sufficient unfairness to taint the unfairness of the hearing as a whole, it doesn't matter that some things were got right. Is that a...
My lord, yes, one cannot rescue unfairness by looking at the overall process and the substance of the determination.
No, well,
that's the point. And I think the point is that the tribunal found unfairness. That's the starting point.
The upper tribunal found unfairness. Yes.
And once that is done, one cannot then reconstruct the process by the judge saying, well, actually, I've looked at it, I understand what happened, I understand what the judge was thinking, I've looked at the determination, it's all fine, it's all fair.
Yeah, and
that is impermissible.
And that's the point you make at para 42 by reference to Abdi.
My lord, yes. This might, my lords and my lady, be entirely irrelevant, bearing in mind the observations made a while ago, but at 46 onwards, I refer to other matters that the tribunal did not accept, which we say the court is entitled to take into account, but of course unnecessary if the tribunal's findings are sufficient. And then at 53 onwards, the failure to take a structured approach, and I think I would have made my submission on that. The submission is set out quite fully in the skeleton. I don't need to take my lords and my ladies through it. And then in the conclusion, and again, of course, it's, I think in the respondent skeleton, it's put much higher than the appellant has ever put it, and much higher than Lady Justice Lang put it. And I feel that the appellant must address it, because Lady Justice Lang, in granting permission, referenced this point specifically as a compelling reason to grant permission, which is the context of the judge being a former presenting officer.
Yes, yes, and not what she put it as a ground, she put it as a reason for allowing a second appeal.
My lord, yes. And so in addressing it, and my lord will see that, my lady will see that it's not part of the core argument, it's addressed in the conclusion. And at 63 we set out the way that Lady Justice Lang addressed it in the grant of permission, and it was a detailed grant, so she had taken the trouble to read everything very carefully.
Yes.
The appellant's position at 64 is that he doesn't need to rely on this point to make good his appeal, but that in response to the observation from Lady Justice Lang and the position put by the respondent in his skeleton argument, a former presenting officer is very different to a former representative, whether that's a solicitor or a barrister, because of course a solicitor and a barrister are representing all...
Perhaps I quite understand how you're framing this part of your case, Mr. Chafferty. But doesn't it really come down to this? If someone with a particular background, and this case is being a former Home Office presenting officer, but it occurs in all areas of the law. You can have a criminal judge who's always been a prosecutor or worked for the CPS. You can have all that. If they have, in fact, acted unfairly and in a way that appears favourable to the prosecution or whatever it might be, that is why the thing is overturned. And you don't add anything. Whatever you might suspect, it's because of their background culture, but who knows about that? You'll never know that. Sometimes it works the other way, that when the gamekeeper turns a poacher, or the poacher turns a gamekeeper, they are actually particularly tough on the faults of the side they use. So all that doesn't really get you anywhere. For myself, I think this appeal turns on actually how the judge conducted himself. And it's not really a matter of interest or importance to this court whether that was because he was subconsciously affected by his background or not. That's just an inquiry we needn't and probably shouldn't go into.
My Lord, I take the point, which is why it's in the conclusion, it's in response to what Lady Justice Langer said, and we don't rely on it in our core submission. I think just for the sake of completeness, of course, the appeal before the upper tribunal, what the appellant had said in his witness statement was that he was extremely upset when he found out that the judge was a former presenting officer. It might be, and it might be this case, it might not be this case, but it might be that in certain circumstances, the conduct of a judge includes that knowledge that there was
One
a former...
could, yes, I'm not, I agree, there could be extreme cases where it is actually apparent from the things said where the apparent bias, probably in not in a case as bad as that, the actual bias is coming from, and then obviously you must rely on it. But in a case here where it's the things themselves are unfair in themselves, if they are, guessing why that was the judge's mindset isn't really going to help anybody.
My Lord, no. And as we have said, there are far more serious and consequential matters that the appellant relies on, and one doesn't need to trouble the court. In light of my Lord's and my Lady's indication, I don't need to trouble you further with that. It's addressed in the conclusion because it was something...
No, I see exactly why you've done it, and it's helpful that you have, but well, let's leave it there for the moment.
Unless there is anything further that I can assist my Lords and my Lady with at this point, those are my submissions.
No, you haven't, but this is not a criticism. I think you haven't taken us to the law in this area because you've set out the important passages in your skeleton argument. I think it's fair to say, I think I'm speaking at least for myself, that dividing this up into rigid boxes and saying this is a fairness argument, this is a bias argument, this is a descending into the arena argument, is unlikely to be helpful because they do tend to bleed into one another.
Yes.
But all the more reason for you not to have offered us any particular structure on that. So I'm not complaining. I'm just really flagging that up as
yes.
how I think my Lord and my Lady see it.
It's all in the skeleton. I don't think one needs to go beyond what is cited in the skeleton.
Yes, well, it's probably even less necessary than if you look at the case I mentioned earlier, but
yes.
Do just in case.
Certainly we will. And we managed to get quite a light bundle of authorities.
You did.
Which I was very happy with.
You did.
And I hope that's been of assistance to my Lords and my Lady. Unless there's anything further.
Thank you.
Thank you very much. Well, Ms. Anderson, if you had as it were, a 5-minute preliminary point you wanted to take, let's do it. If you haven't, we could maybe rise it again at 5-2, if that...
My Lord, I certainly have no sort of thought to go away with, as it were, if that's what you had in mind. I will address my learned friend's submissions. The only point I think I really do need to be clear on, which I'm not sure I am, but perhaps I can do this with discussions with my learned friend, is whether we really are looking at sort of an unfair procedure, a sort of actual bias in a sense in the behaviour, not, or whether it is just appearance of bias. And I appreciate my Lord's comment about let's not be too pedantic about putting this in boxes. And I'm going to go to Gourley, where I think it manages to sort of make them all interweave and give the tests there, and so I'm happy with that. But I'm still, at the moment anyway, and perhaps this could be clarified, unsure of whether we're only looking at the appearance of bias or whether it's said that there is an actual unfairness here in the way the hearing was conducted. But perhaps we can deal with this in some way.
Yes, I wouldn't think it's likely to be helpful to have private conversations with Mr. Jafferty about this. We've heard his submissions, and if you think there's an ambiguity in those submissions, I think the right way to deal with it is to say so to us, and we'll consider whether we agree.
Yes, but I'm not meaning it by way of criticism. I'm only meaning to do it by way of making sure that I'm addressing the right issues for the court. So, even so, let's do that in open court rather than in private discussions. I think it puts Mr. Jafferty in an awkward position for you to get up and say, I've spoken to him and he didn't mean this and he did mean that. My Lord, all I was going to do was that perhaps at the beginning of the, when we resume after the short adjournment, that I could just clarify the position. I didn't mean to...
yeah, fair enough. No.
I was just raising it that was something that I'm not clear about. If I'm still not clear about it, then of course we'll deal with it in open court. But I did just want to flag it up because that's the only issue that I think might take a bit of time
I mean, is it realistic to think that normally the respondent doesn't take as long because all the legwork has been done by the appellant? So we're not looking for 5 minutes here and 5 minutes there, are we? Otherwise, I'll just sit at 2, I think.
Oh yeah, absolutely, my lord.
Yeah.
I usually have a rule of thumb of half the time of the appellant. I don't think there's any difference in this case, so I'd hope that
We won't absolutely hold you to that, but we will encourage you to that.
And there's always the incentive of finishing on the day, isn't there, George?
We'll certainly finish on the day. You may find us being quite tricky about that, but
we all have an interest in that, my lord. So I'm just saying I have no interest in overly elaborating submissions.
thank you very much. 2 o'clock.
Prize available.